now talk about the Supreme Court ruling. More reactions and responses are still coming in on what people term as the controversial reasoning and ruling by the Supreme Court on the 4 vacant seats in Parliament. Yesterday, the Superior Court released the 109-page ruling. That's a majority 5-2 decision that said Speaker of Parliament Alban Bagbane's declaration of those 4 seats vacant is unconstitutional. What people have been commenting on now is the 2 dissenting views. Justice Tanko Amadu, who wrote, and I'm quoting what he wrote, "I do not hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the Honorable Chief Justice and the rest of my brethren in the majority that not only do I fundamentally disagree with their conclusion, I, with all due respect, also find the decision an aberration to the established and accepted judicial position of this court, which with profound respect I hope in no distant future the resultant usurpation of the constitutional prerogative of the High Court incidental to the majority decision will be reversed." That's one of the dissenting views. The other one is Justice Lovelace Johnson. She also says that the Supreme Court did not have proper jurisdiction to rule on the matter because it's the High Court that are properly clothed to rule on cases that had to do with parliamentary seats. Now, there have been also the argument about how Parliament intends to resolve this matter. Let's listen to a former director of the Ghana Law School who has been speaking to us, Mr. Kweku Ansasari.
It's a pronouncement of the Supreme Court, and since the Supreme Court is the apex or highest or final court, it is, if decisions are binding on everybody, on the whole nation. But according to Article 129 Clause 3, the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so. When it appears to it right to do so. So when that right time will come, nobody can predict. But we all hope that it will be reversed sooner rather than later.
And again, per the judgment or the ruling, the Supreme Court failed in that accord to direct the Speaker to reverse his decision. Does the determination of the Supreme Court that the Speaker acted unconstitutionally automatically means that the Speaker must reverse his decision, or the Speaker would have to wait for a directive from the Supreme Court before?
Well, the Supreme Court, as you rightly pointed out, made no consequential orders.
Yeah.
They granted a declaratory relief, which by themselves do not bite. Now, a much more fundamental problem with the majority opinion is the fact that the majority themselves did admit that there was no reasonable course of action in the substantive rate. And if there was no reasonable course of action, there was only one court open to the court to throw out, the action. That they failed to do. And if they considered that there was no reasonable course of action, they couldn't have, grounded any biting orders, on something, that did not exist. In law, our Supreme Court has, over the years, proclaimed or declared that you cannot put something on nothing and expect it to stay there. It will collapse. But you see, the exercise the majority engaged themselves in yesterday was, quite interesting. One could see the justices constituting the majority struggling very hard to find something to write home. They couldn't find it. If I were the majority, I simply would have thrown out, the burden and then free myself, extricate myself, from the problem that, they brought, upon themselves.
That's a former director of the Ghana Law School, Kweku and Sansari speaking to my colleague Havila Kekeli. Let's speak to Member of Parliament for Medina, human rights lawyer, Francis Sosu. Honorable, good evening to you. Thank you very much for joining us once again.
Yeah, good evening and good evening for having me.
The last time we were speaking, we were looking forward to reading the reasoning of the justices of the Superior Court. I'm sure by now you've had time to read the 109 pages. Now, Mr. Asari is saying that the majority, that's the 5 people who accepted this decision, were struggling very hard to write something home. Did you see that when you were reading the reasoning? I've lost Mr. Francis Sosu on the line. We'll try and re-establish contact with him as we go for a quick message from our sponsors. Remember, 505 is brought to you in association with Betway Bet Saver offer. I'm told that fortunately we've been able to re-establish contact with Honorable Francis Sosu. Honorable, can you hear me, sir?
Yes, please, I can.
Okay, fantastic. So I was asking you whether you also saw that the justices were struggling very hard to drum home their point as the reason they said the Speaker's declaration was unconstitutional.
Well, absolutely. I mean, I took time to read over the 109 pages document, and I was looking for one particular thing, and that was the discussion about the purpose for Article 97(1) GNH. You see, when you have to, or when you are called upon to do interpretation, all the canons of interpretation that we've learned, either from Asari and Attorney General, Ejetum and Attorney General, Aaron Barak, and all the authorities that have discussed what constitutional interpretation is about, you begin with what we call the plain meaning or the ordinary meaning of the words. If the ordinary meaning would lead to some form of ambiguity or absurdity, then you have a license to depart and try to ascribe a different meaning to what you read. In the first place, the ordinary meaning of Article 97(1) GNH were very clear. So there was no ambiguity. It doesn't lend itself to any ambiguity. So there was no basis for interpretation in the first place. So once you decide to give an interpretation where there is no need, then you begin to struggle, because it is usually when the ordinary meaning is not very clear, then you are then called upon to ascertain what we call the spirit or the purpose at the core of the text, so that your interpretation will be given to give effect to that purpose or to that spirit behind the text. So once there was no ambiguity, it was so difficult to now even ascertain the purpose of Article 97(1) GNH. And so I was trying to figure out throughout the ruling or the judgment to see whether the Supreme Court took the time to explain why would the framers of the Constitution even introduce a provision like Article 97(1) GNH. But I never saw anything like that. So it was at that point I realized that indeed the majority bench were really struggling to put something on nothing, and basically trying to create an interpretation which doesn't exist.
But they did. They talked about cross-carpeting or changing political affiliation whilst you are still in Parliament. So, in other words, futuristic. If I am a member of Parliament on the NPP ticket, and I'm in Parliament, and I decide that next year I will not contest on the party's ticket, but another party, you cannot hold me for that decision now until maybe next year, or when I seek to change right now and say I'm now going to sit with the NDC. That is when that Article 97(1) GNH
applies. So that is where the problem lies. You see, when we talk about political loyalty, you can't say that you are currently in Parliament in the name of NPP, and yet you are telling them that next year you'll be running on the ticket of NDC, and then they will allow you to continue to remain in Parliament, to be with their caucus, to have caucus meeting with them, to have discussion with them, be on committees that they are supposed to be on, and take decisions on behalf of the NPP in this Parliament. That's what the problem is. You see, so when you talk about people changing political colors or people changing loyalty to political parties, one, it comes through declaration. Two, it comes through the party itself either expelling you out of the of office, and three, it may come through you taking a positive step by filing processes before the EC and voicing your intention not to be with the party anymore. And once that is established, you can't continue to be in parliament in the name of that party.
But the
Supreme Court,
the Supreme Court disagrees. It says that by mere filing, you cannot use that. And in this case, the party has not sacked them.
See, unfortunately, there is not like mere filing. You see, because the act of filing with the EC is a statutory step. And you recall that one of the reasons why Sh0cks was pursued, and to the extent that the Supreme Court even made an order to expel him from Parliament, was just because of his filing of nomination. And they claimed that at the time he was filing the nomination, he was making declarations. That is the point. So the point of filing nomination is so critical, because at that point you are making a positive declaration that I don't believe in the ideologies of the party that brought me to power, to Parliament. I don't believe with them. And guess what? Look, you see, the absurdity that this interpretation brings is you take the is it Amenfi West issue, for example.
Amenfi Central.
Amenfi Central. Sorry for
Agona
example.
West.
No. Amenfi. No. Like so, I'm using the NDC as a typical example.
The NDC. Amenfi Central.
Yeah. So you have a member of parliament who goes to primaries and loses, and having lost, says that I no more believe in the NDC and will no more run on the ticket of the NDC, and I'm going on independent. Now the NDC candidate in that constituency is being fought and is being disrupted, is being undermined by this same MP who is an NDC MP in that constituency, who have made a positive declaration that he doesn't believe in NDC anymore, and notice of post have actually been published by the EC. Under those circumstances, it doesn't make sense. In fact, it is repugnant to good conscience to say that under those circumstances, that same person can come to Parliament, sit with the NDC caucus, take decisions with the NDC caucus in the interest of the NDC in Parliament. It won't work.
But now, as it stands, that ruling has been given, and they are supposed to be in Parliament until after 7 December, or let's say the 7th of January 2025, better still, midnight.
Well,
of that
unfortunately for them, when you look at the ruling, I don't think that the Supreme Court made any consequential orders in respect of that. Unless the plaintiffs go back to Supreme Court for a review, for an order to be directed at Parliament for that purpose. Otherwise, what the Supreme Court has done is to make what we call mere declarations and express their views in respect of the matter. And in any event, you know, the account man will tell you that I see agree any back for trim. To the extent that you have two people dissenting who have expressed their opinion clearly that the majority bench was completely wrong and that they had needlessly usurped jurisdiction that they did not have. I can assure you that unfortunately for these people, that space may not be available to them until that 6th January 2025, unless they go back to Supreme Court for those orders. Because as we speak now, the earlier order suspending the whatever the statement or the announcement speaker made no more exists. And when it comes to Parliament, we work with standing orders of Parliament. We haven't amended our standing orders yet. Parliament has not sat down to amend any of those standing orders. So what pertains to Parliament still is the status quo, unfortunately for them.
What does that mean? It means that these four will not be admitted if the Speaker decides to call Parliament now?
Well, I'm saying that as we speak now, the status quo of Parliament, what is in Parliament is what remains.
So what is in Parliament?
Well, the last announcement Speaker made, and that is captured in Parliament official records. In fact, as we speak now, we have not seen Speaker give that announcement. As far as Parliament is concerned, we have not even convened to take a decision to adopt the vote and proceedings of Parliament. So since she can make that announcement and this drama began, we have not gone back to Parliament. And so nothing will change as far as parliamentary proceedings is concerned, particularly because Parliament, by law and by the Constitution of Ghana, regulates its own procedures.
Which is subject to the Constitution.
Even the Supreme Court decision is subject to the Constitution. That's the constitutional supremacy.
So will members of Parliament come before we go to the polls on 7 December?
Well, it doesn't. For me, it's not likely. We have just about 3 weeks to elections. Everybody is busy in this constituency campaigning. I mean, what are we coming to do in Parliament at this time? When the reason for which you are in Parliament is the people, and we need to be with the people at this time and talk to them and account to them why they need to give us a second chance to go back to Parliament.
But there's supposed to be an appropriation budget for salaries of public sector
workers.
I
don't think the government knew that there was supposed to be appropriation. Otherwise, they wouldn't have taken the route they took.
So, as far as you are concerned, members of Parliament will come back after the elections on 7 December.
Most likely.
Okay. Honorable, thank you very much that you joined us. Member of Parliament for Medina and also a human rights lawyer, Francis Sosu. Let's go for this.